Welcome to NSL Unscripted, a national security law podcast, brought to you by the National Security Law Department at the U.S. Army's The Judge Advocate General's Legal Center and School. We bring you conversations and hot topics from NSL practitioners today, and hope you enjoy this episode.
Hello, and welcome to NSL Unscripted. My name is Lieutenant Colonel Dan Maurer, Associate Professor of National Security Law here at the Army Judge Advocate General's Legal Center and School. It is my privilege and good fortune to get to talk with our guest today, a friend with whom I've learned an enormous amount since I first reached out to him with a cold call in 2017. Dakota Rudesill is an Associate Professor of Law at The Ohio State University's Moritz College of Law, where he teaches national security law and process, secrecy and surveillance, legislation and regulation, the legislation clinic, and professional responsibility. His scholarship has appeared in or is forthcoming in major law reviews and journals, including Georgetown Law Journal, Stanford Journal of International Law, Yale Journal of International Law, and Harvard National Security Journal, among many others. He's a member of the editorial board of the peer-reviewed Journal of National Security Law and Policy, and he has served as the chair of the National Security section of the American Association of Law Schools. A particular area of emphasis in Professor Rudesill's work is intelligence and secrecy, including secret law, as well as arms control, nuclear weapons, legislation, and the experiential learning by doing training of professionals. Two of these subjects, secret law and learning by doing, we'll talk about here today. Prior to joining academia, he served the U.S. Congress for 9 years, doing national security legislative work for the Senate Budget Committee and Senator Kent Conrad. In the executive branch, he served as a member of the Obama-Biden presidential transition team, where he advised the president-elect's nominees for the Director of National Intelligence and the CIA Director. He's also served in the Office of the Director of National Intelligence and on the President's Detention Policy Task Force at the U.S. Department of Justice. His JD is from Yale, which I hear is a pretty good law school too. Professor Rudesill, welcome to NSL Unscripted.
It's an honor to be here.
So let's get started and dive into one area of law that you're particularly engaged with. That's secret law. Now, here at the JAG School, as you know, we train brand new judge advocate officers who are complete novices in military law, as well as experienced JAGs getting their LLMs and some select commanders. One thing that we teach that is common to all of those student bodies is the value of transparency of process and how following the rule of law from big issues to small ones is critical for the legitimacy of the military's activities, whether from a domestic public view, the media, international bodies like the ICRC, our partners, our allies, and competitors. In 2015, you wrote a fantastic and comprehensive, let's call it an expose, called Coming to Terms with Secret Law in the Harvard National Security Journal. Secret law sounds a bit nefarious and sinister, deliberately undemocratic. So can you define what you mean by secret law and maybe provide an example or two?
Sure. Well, I appreciate the opportunity to talk about this because it's one of these issues. I kind of call it like a submarine issue. It's kind of out there, but it's below the horizon. And I think that it needs more attention than it gets, especially because a lot of lawyers who work in government will run into it at one point or another, or at least run into the issue, and they may not be equipped to grapple with it. So I'm delighted to have the chance to talk a little bit about it. So by using the term secret law, I actually don't mean anything nefarious. I just mean what it sounds like, law that is secret. It's a legal authority that is a binding legal authority. It requires compliance, but it's secret. And by secret, I mean, in terms of the definition, just kind of in colloquial terms, non-public. And it can be secret because it is secret under the classification system or top secret or any of the other designations, or it could just be not released to the public, to be functionally secret. So that's what I mean by secret law that requires compliance that is not public.
Can you give me an example of what you just called functional secret? So it's unclassified but not released or releasable to the public.
Yeah, so there's a vast body of this, and it's overwhelmingly in the executive branch, which is kind of not surprising, right? Because, you look at the federal government, right? The largest piece of it is the executive branch because it can do stuff, right? It's got people in the field who can do stuff. It has this entire administrative apparatus with it, both civilian and military. And you look inside the federal government and you find a really extensive body of, again, what I would say meets the definition of secret law, but it's not classified. And it doesn't even have the, unclassified for official use only, or even, the C designation, right? Confidential. Instead, what it is, it's administrative law that is not released to the public. So, for example, at the Office of Legal Counsel at the Department of Justice, there is a vast body of opinion law produced by OLC, which under statute is the binding law of the executive branch unless it is overridden by the Attorney General or the President. And the vast majority of that, inferentially, we don't know, but that's what I hear, that's what we all hear, has never been released publicly. And that's not because, again, there's anything nefarious afoot at the Department of Justice, over the decades, right, of administrations, both blue and red. Instead, it's that when the lawyers at OLC get asked a question and they produce an opinion on that issue, it's binding, but they don't post it to the website. They don't publish it in the Federal Register. And you look at the agencies as well, and it's the same thing, right? So when you get a legal opinion from the general counsel of your agency, right, which is binding on that agency, right, the vast majority of that stuff is not published. And the vast majority of it is not even classified. It's just not released. And potentially the unclassified stuff can be surfaced by FOIA. But as your listeners know who have some expertise with regard to FOIA, the Freedom of Information Act, when making those requests, you've got the requester basically has to know what they're asking for. They can't go on broad fishing expeditions like USDA, release all binding legal opinions, right, on like soybean. They won't grant that. That's too broad. You need to get specific. You need to talk about a specific document. And so for that reason, you've got this vast body of basically opinion law within the executive branch. And then there are also subordinate directives, if you will. There are administrative directives issued by executive branch officials pursuant to the statutory authority they have, maybe the authority they have under a reg, which has been published in the Federal Register or elsewhere. Maybe even it's pursuant to delegated Article 2 presidential constitutional authority, but they're giving instructions, and those instructions are binding. And again, many of those are public, but the vast majority of them are not. And so that's really a body of secret law. The harder core secret law that I think probably most people would think about when they hear the term, secret law, is national security secrets. And those generally are classified, and those can, classified documents can include both secret fact and secret law. And I think that that's an important distinction, which has not always gotten recognized in the conversation that we've had about secrecy.
So what is the difference between secret law and secret fact?
Well, I think it's an important one. Secret facts are just kind of what it sounds like. It's just factual information, right? It can be, it could be an intelligence assessment, right? Like this is telemetry we collected with regard to the latest, Russian ICBM launch. It could be assessments, it could be estimates, it could be foreign intelligence, factual information that's intercepted. It could be military information. It could be just, information about a new weapon system, right? It is factual information. And you can make, there's the long-standing and really, really rich conversation about secrecy in that context with, on the value, kind of the standard values here that are cutting against each other. On the one hand, in our constitutional system, the people are sovereign, right? The Constitution says we, the people. The federal government operates with power delegated from the people to the federal government under the Constitution. And for the people to be self-governing, they need to have knowledge. They need to have public information, right? To be able to speak and have opinions and make informed votes. Cutting against that are a number of considerations. I think the two most powerful ones are, one is basically not tipping the bad guys off, what our capabilities, plans, intentions, operations are, right? What we're collecting via intelligence, the identities of our assets in the field, foreigners who are spying for America, exquisite cyber and intelligence collection capabilities, right? Basically not tipping the other folks off in the world, right? And another value that cuts against this transparency principle that we need is deliberation space for people in government to have candid conversations that are not in front of the cameras, right? Not under the blinding light of publicity, because they're talking about this stuff that is, I think, properly confidential. And also simply because to explore issues, it's valuable to have spaces where you can have candid conversations and people they can play devil's advocate, right? They can just like spin out all the possible arguments that could be made, or all the different ways we could understand this new piece of intelligence that we've intercepted. And to have that deliberation space is a very valuable thing. And when you don't have any confidential deliberation space, you're going to have lower quality conversations, right? Even if you're talking about, non-national security stuff, it's still going to be a lower quality conversation. So, in a republic, we have to find this balance between transparency and a knowledgeable public and, secrecy. And that's difficult enough when we're talking just about secret facts. It gets even more difficult when what's classified is the content of the law itself. And that's because law is just different. Law is rules. Law is an embodiment of what Madison in the Federalist told us we had to do, and Hamilton, which is that because human beings are not angels and will tend to abuse their power and to be selfish and act in personal and factional interests and not the public interest, we need rules. We need guidelines to constrain them, to channel their conduct in a way which generally benefits the republic. So it's rules, right? And if the public doesn't know what the rules are, it gets tougher, again, for them to make decisions at the ballot box. It gets tougher when those rules concern the conduct of the people themselves and not simply their government. It gets even tougher because then the citizenry doesn't know how to conduct themselves in a way to avoid catching kind of the eye of Sauron, if you will, right? So law is just a little bit different. And one other consideration I'd mention too about how law is different than fact is that in our system of separated powers and federalism, the other branches of government, when they're doing their lawmaking work and law interpreting work and law administrating work, right, they need to know how the other branches understand the law. And so if you've got one branch of government, right, or maybe two of them, they are making rules and the other branches don't know about it, one or both of them, they're not able to do their constitutional work in a full way. And so with secret law, I think that this general secrecy dilemma and tension, I think it gets even tougher because, again, you're talking about the rules.
Yeah, but you don't advocate for all or nothing. We should either have secret law or not have any secret law, right? You make a distinction between deep secret law, right, and shallow secret law. Can you kind of explain what you mean by the shallowness of it?
Yeah, exactly. So let me talk about the shallow versus deep distinction, and then I'll talk about what I think are kind of three broad ways ahead with regard to secret law. So the shallow versus secret distinction has been around for a while. One of the best analyses of it was from a scholar named David Posen from Columbia. So the basic idea with shallow secrecy versus deep secrecy is with shallow secrecy, there's a secret, but you don't know what the secret is. It's kind of like, there's a black box sitting on your desk. You just don't know what's in it. And maybe you can make some inferences about the size of that box. Is it the size of a breadbasket? Is it the size of a refrigerator? You can make some partially educated guesses about what's in it. That's a shallow secret. There's a secret, but you don't know the secret, right? Or all the detail. Deep secrecy, in contrast, is a secret and you don't even know the secret exists, right? You don't even know to ask a question, what's in the box, because you don't even know there's a box. And when you think about the law, I think that this shallow versus deep secrecy distinction is especially important because when you have a branch of government or some entity, it's creating deeply secret law to bind its own activities, to broaden its own understanding of its authority, to do things that the other branches would care about, or to do things that infringe potentially on the rights of the people. When one branch of government is doing deeply secret law, the other branches have no idea even what might be going on at all. In contrast, where you have shallow secrecy, at least there's what I call, in my scholarship, a bell ringer. There is some sort of notice, either to just the other branches of government or to the public at large, that a secret law has been created. And maybe there could be just something general on it, like surveillance, something like that, right? Like that's not enough. For example, if the Office of Legal Counsel were to write a new binding legal memo, which is binding on the executive branch on the subject of surveillance, and one line was published in the Federal Register saying that on this date, the OLC signed out this memo. It's on surveillance. If you're Al Qaeda, if you're the Chinese, that is useless to you. They know we have a massive surveillance apparatus, right? There's nothing they can do with that word surveillance that tips them off to anything that we might be doing. But what that does say to the public is like, hey, the government is doing something with regard to law on surveillance And then at that point, what the public could do is that they could ask their members of Congress to go behind the curtain and have a look. And if those members of Congress are comfortable with what they see, then things can keep trucking along. If they're not, then Congress has got a number of methods it could take, from public law to its own secret law, which I write about, to having hearings, to having meetings. Congress can then do something about this. And then the public have some general sense of just like, well, how often is our government, right, creating secret law? That's a valuable data point for the public. Do some presidential administrations seem to be doing more secret stuff than others? And on what general topics are they doing the secret stuff, right? So I think that this kind of deep secrecy versus shallow secrecy distinction, I think it's an important one.
It seems to me like there are three levels of questions that the public would be interested in knowing, right? One is that there is or is not a secret. Two, what the content of the secret is. And then three, the rationale for why it's being kept secret. In your study of whether it's the executive branch or the legislative branch's versions of secret law, are there examples where the proponent actually describes a rationale for why it is under the secret umbrella, why it's being withheld from the public's awareness? Or is it just it is what it is?
Well, so under the law that regulates the classification system generally, people who make classification decisions are obligated to articulate a reason for doing that. And many of your listeners will have encountered these documents. It's that little bug down in the corner that says reason. You have to come up with some sort of reason for this. And the you're in a hurry version of it, and I say this as somebody who worked in the IC, and on Capitol Hill I saw class documents too. I mean, when you're in a hurry, it can be something very, very broad, just foreign affairs information, something like that, but hopefully you do a little bit more than that, and you go a little bit farther in providing something like that. And then there's some more specific rules that are elsewhere. The Office of Legal Counsel has some internal guidelines on this, and other parts of the government do as well. And basically what they're trying to say is, like, you need to make a good argument about public interest about this. It gets pretty easy when you're talking about, I think, the easiest cases when it comes to secrecy, which is stuff like military plans, identities of covert agents, capabilities of secret weapon systems and intelligence collection capabilities, technical details, stuff like that, right? I think it gets a little tougher when you're talking about secret law, because again, it's the rules, and for all the reasons that I mentioned. And I think that it's one, I think, can kind of get a better sense of the entire system if you just kind of think about the three main magnetic poles or sources, if you will, of secret law in the federal government. And this is what the study that I did a few years ago really just kind of aimed to do in kind of a comprehensive way. Because up until then, there'd been a conversation about secret law in the United States going back a half century, but it had been very partial and ad hoc. And usually it was in response to a scandal of some sort that had broken out. And it was very narrow on this kind of like, this particular agency didn't release this particular legal authority that maybe should have in the view of the public, right? And that's a scandal. And then there's some response to it. But nobody had done a categorical, comprehensive analysis of what the federal government is doing based on the public record. That's, writing in the public, that's all I can do. So I sat down and I did that. And if you have trouble sleeping, you can read the full 150-page version. There are shorter versions that I've written for Just Security and for Lawfare that you can go and have a look at. Those are a little bit more digestible. But let me give you just a quick tour. So the best recognized secret law, I think, probably for most people, is actually judicial branch secret law. And that's because people, at least in the national security world, have probably heard of this thing called the Foreign Intelligence Surveillance Court, or FISC. There's an appellate body called the FISCR, and this was created by the Foreign Intelligence Surveillance Act of 1978, and it's a special federal Article 3 court which reviews government requests to do electronics intelligence collection against Americans or inside the United States for foreign affairs purposes. The regular federal courts administer the surveillance regime for collection of evidence in criminal cases. But this Congress created this new system for what's called foreign intelligence information, which is information about foreign countries, developments abroad, and also international terrorism. So there's this Foreign Intelligence Surveillance Court. Its existence is public. You can look up the judges who are serving on it on a rotational basis, but all of its work is classified because you're talking about surveilling suspected Chinese and Russian agents inside the United States and that sort of thing. And so this court just kind of trucked along from 1978 until the early 2000s, doing kind of what we call, I don't know, it's kind of like the Koch classic version of surveillance for foreign intelligence purposes. Looked a lot like what regular federal courts do in considering government applications for surveillance authority in criminal cases. It was just onesie twosie court order requests from the FBI and the NSA to surveil the communications of some individual that they suspected to be an agent of a foreign power. And they needed to convince the judge there was probable cause that this US person was the agent of a foreign power, and probable cause that this person would have foreign intelligence information. And it was onesie twosie, and secrecy made sense, right? You don't want to tell this person you're suspected, if you've watched the show The Americans, right? You don't want to tell your suspected Russian agent, like, hey, we think you're a Soviet agent. We're going to now have a process to think about maybe surveilling you. You wouldn't tip them off. That's why it's secret. It got problematic because the Foreign Intelligence Surveillance Court during the 2000s and the post 9/11 period, after a few years, was read into a program called Stellar Wind that the NSA during the George W. Bush administration had developed, which was doing surveillance, targeting the communications of Americans and doing collection inside the United States, but not complying with FISA, the Foreign Intelligence Surveillance Act. And this was initially done on the president's Article 2 authority alone, under a classified memo written by the Office of Legal Counsel at the Department of Justice. And then this program, after a few years, there was an effort to basically say, well, let's try to get court blessing for this. So they went to the NSA and the DOJ and the White House went to the Foreign Intelligence Surveillance Court and made some arguments to them about how maybe you can find in the statutes that are out there some hooks for some pieces of this. And we're able to convince the Foreign Intelligence Surveillance Court, in many cases with some modifications, okay, there are pieces of this that that the court can authorize. And it started to do this in an evolving body of what was basically classified common law, where the court was writing top secret opinions about top secret activities, then citing those other opinions it had. And this exploded into the public knowledge, most notably when Edward Snowden in 2013 got a bunch of these documents and just started publishing them through the Washington Post and the Guardian. This was deeply shocking to people. And so there's this body, again, of classified directives and orders. And Congress has made some reforms to that to create some transparency that we can talk about. But the Foreign Intelligence Surveillance Court still operates in secret and can produce secret documents. Moving on to the executive branch, and I'll be a little quicker about this. That was a fairly deep dive. I've already referenced the ability of the Office of Legal Counsel of the Department of Justice and other agencies to write memoranda which are binding and are secret. And so there's that body of law. And again, we don't know what size, body of law this was. A lot of it is really boring stuff. There are all sorts of unpublished memos on, I'm sure, Department of Commerce activities and USDA. Even the classified stuff, I'm sure some part of that is pretty boring, but there's a certain amount of public awareness of it. Again, going back to the Stellar Wind controversy, in part because what the Office of Legal Counsel did, and there's specifically a couple of lawyers there, especially John Yoo, who's a Berkeley law professor, deployed a minority theory of executive power. And by that, I mean that it is not, if you read the Supreme Court's jurisprudence, if you read the general body of scholarship, it's not the theory, right? And it's this idea that basically the president can say national security and be free of constraint by statutes that Congress has written in execution of Congress's enumerated authorities, which you can read in Article 1, Section 8. It is a theory that has not been endorsed by the Supreme Court. In fact, the Supreme Court has, in a long line of cases, the Youngstown and Bareem cases, repeatedly overturned executive actions for statutory violation. But that was their theory. And so they deployed, without telling the other branches initially at all, this theory of executive power that was not the majority opinion among judges and scholars, and then used that to say, well, the president doesn't need to comply with the framework statute on national security surveillance when it comes to collecting the communications of Americans. So when this came out initially in 2005 and more came out in the years that followed, just enormously controversial. Kind of a sibling to this was the torture memos that were also written by John Yoo and some other lawyers. And there again, they deployed a really expansive understanding of the president's authority in secret. They also did statutory interpretation work, which just reconstructed statutory law about torture to be so narrow that it was just shocking when it was released. Defining the ban on torture down to be only banning the level of pain associated with organ failure or death. That's all torture is. Exceedingly narrow definition, right? So that's executive branch secret law. And just to briefly finish our survey here, so the third branch of government that I haven't mentioned as much here is actually the first branch of government of the Constitution, which is the Congress, the Article 1 branch. And what basically there really hadn't been any writing on this of any extent at all until my study in 2015. And I was shocked by that because I worked on Capitol Hill for 9 years. I knew that Congress was creating secret law, but I just thought well, this is well accepted. And when I become a law prof, I'm going to join this really rich conversation among scholars about congressional secret law. Well, in fact, there was almost none. There was a paragraph in a work by a philosopher. I mean, just almost nothing. And so I did this study. I studied, of course, just the public law. That's all I can write about. I read every reference in the public laws and in congressional reports to what they were doing. And then I did a stat analysis of it. I analyzed the language. And so here's the bottom line. So since the late 1970s, what Congress has been doing, first the intelligence committees, then the armed services committees, and then the appropriations committees, is in annual national security legislation, the Intelligence Authorization Act, the National Defense Authorization Act, or NDAA, and the Defense Appropriations Act. Every year, there's a little provision in there. Some bills actually have multiple provisions, but it's a standard basis. The act has one, and it is a public law provision that we can all read that says that there's also law in a classified document that the committee is writing. That classified document, it's on a hard drive or in a safe in the basement of the Capitol, right, in a secure room, copies shared with the executive branch. And Congress did this in response to revelation of intelligence abuses in the 60s and the 70s. And Congress did this basically to bring law to the darkest corners of classified activities in the executive branch, right? They were going to write this secret legislative law to govern classified executive branch activities, right? Which sounds salutary, but the public has no idea what's in there. They're called classified annexes. So they've been created now for 45 years. And you can read my scholarship and you can see how often they're written by Congress, right? Based on the public law references. 45 years, not one of them has ever leaked or been declassified or published. The public has no idea. Like they could be this classified piece of legislation, right? That gets passed every year, sometimes many of them. It could be one line. It could be 300 pages. Nobody knows. I don't know. Even when I worked on Capitol Hill, all I got to see as the budget guy was one line that which was intelligence spending. So I knew it existed, but that's all I knew. So anyway, so that's a survey of the three branches of government. And what I say about secret law is that it is a limited but meaningful and well-established exception to the norm we have that the law is published.
Yeah, and I think you mentioned in your article that most of the secret law being passed, at least from the legislative branch, is kind of internal to government functioning. It's within the branch or between branches. It's not government in its relationship to individual citizens. So it's not like a Kafka-esque criminal statute that you don't know exists and you don't know what you're doing wrong, but suddenly you're arrested and detained and tried for something that you didn't know was a crime.
Yeah, so I'm going to agree with you, but I'm going to complicate what you and I just agreed about. So based on the public record, the 45-year public record, I think what you're saying is right. I think like the overwhelming, the references in the reports and what the senators and representatives, the few times they say anything to the press about this, it sounds like what they're doing is this is Congress doing its normal legislative work just in a secret setting of managing spy satellite programs, weapon, Navy missile programs, stuff like that. They're getting down to the weeds because Congress controls the purse strings. That sounds right. However, we also know, based on the public record, that provisions in these classified addenda govern things like the CIA's drone program, which has been used to kill hundreds of people overseas, including, targeting American citizens, extrajudicial execution on foreign battlefields, like Anwar al-Awlaki. There's an American citizen targeted with a classified U.S. capability And Senator Dianne Feinstein, when she was chair of the SSCI, she said in the public realm that there were going to be provisions, or there were provisions in the classified annex that was law, where the committee was governing these programs in some way. So we know it's not just DoD acquisition program. There are humans who get affected by this, and nobody knows the content of what's in those classified annexes.
Right. So that's a great point. And it reminds me, I want to go back to your earlier comments about executive branch effect law, binding opinions by, say, OLC that theoretically are binding upon the rest of the executive branch. And in my mind, I'm thinking of a situation where, let's say you have a judge advocate and a military lawyer at a tactical operational level who is in a novel situation, a novel set of facts. A commander that they work for wants to do something that has not been done before, at least not in anyone's recent memory. And they want to do something in relation to, let's say, a detainee or a potential target. The lawyer is asked, is this legal? Can I do this? Or am I going to commit a war crime, or am I violating some kind of, domestic statutory law? And the lawyer, having never seen this situation before, not knowing if it's violating the law or not, asks higher headquarters, their technical chain, the lawyers above them, what's the answer? What do you advise? And their response is something like, well, we don't know. Let's ask DOD. DOD doesn't know. Let's ask OLC. OLC says, we know. We've written an opinion on it, but we can't share it with you. So not only do you have this kind of opaque shield between branches, sometimes even within the branch, you have a lack of communication about what the law is or what it's interpreted as. And I'm thinking specifically of a situation involving Guantanamo. And early on in that, in 2002, 2003, there was a military lawyer stationed there who was the advisor to the commander. And the commander was asking about various kinds of practices and procedures that they can apply with regard to the detainees. And the military lawyer asked higher headquarters for guidance and advice, and receiving none, did her best to apply what she knew of the law of armed conflict, and basically gave not carte blanche, but a lot of discretion to the commander to apply techniques that they wanted to apply on detainees for information gathering purposes, for intelligence gathering purposes. And eventually that memo, it was put in the memo form, and it was submitted higher, and it was basically approved by SecDef, kind of as written. But that just states to me that the danger of a context in which senior lawyers, and by senior I mean people at the strategic level of government, are rendering opinions that absolutely affect tactical decision making and advice on the ground. And when there is that opaqueness and not knowing what to do, you end up with bad advice and then bad decisions. So I'm concerned about the tactical level judge advocate trying to give advice to tactical level commanders when the authority is not only not known, but it's not releasable at all. And that to me is a major concern. What do you think about that?
I would agree. And I think that is, what you're describing there is, I think that's a problem of process within the executive branch, because your people, just in the same way, right, that, a soldier has got to know the ROE. The JAG who's offering op law advice has got to know basically the legal ROE, right? Not just the ROE, right? But just, what are the legal standards? They need to be able to understand that stuff and apply it. And so that's an example where, the military service, the Joint Command, need to be working with OSD and the General Counsel Office. They should then be in touch with OLC and making sure that, that basically like the law gets to the field, right, in a way which appropriately protects, secrets. But it's hard for me to imagine, right, that there's some secret in a DOJ memo, which is just too hot for people who are applying force in the field with lives on the line. I mean, I think that you have to coordinate that, and I would say too, a related issue though, I think is just kind of thinking about, okay, well, how much of that interpretive law, which happens lower down in the pyramid shaped, org chart, how much of that can stay classified, and, for how long, and, whatnot. And that's kind of a tough issue. I would say a good rule of thumb is that if basically the interpretive work is going into a direction where you're ending up with something that seems like a pretty novel interpretation of the law, that's got to get reported up. So people who are higher up in the organization, can understand that. If there needs to be some sort of adjustment made to how the Department of Defense, General Counsel Office, right, like understands the law, they can engage on that. Potentially they can go to OLC. Potentially they can go to Congress. The system has got to work with, information flowing. I think people at the field level, I don't think need to worry too much about the secret law problem, provided they feel like they understand the content of the law, both what's public law and not public law, and the communication is working. I think that that's appropriate. I think where you end up with situations with people are trying to keep things buried that really should be moving up and down the chain, the legal chain in particular, I think that's a problem. And where you're going into kind of novel areas of law, think about like AI, for example, right? Like think about some of the work maybe that, Cybercom is doing on AI or something like that. This is precedent setting. This is impactful. There needs to be that communication kind of up and down. And the last point I'd make about that too is I think the first principle that I offer for kind of what to do about secret law, which is that I basically in my scholarship, I sketch kind of three broad directions we could go with regard to secret law. One is what I call live with it, which is to say like live with the current system we have. It's messy, it's imperfect, but big controversial things tend to get leaked and surface. Maybe that's okay, right? The country's still around. Let's just keep on trucking, right? Live with it. Second option is abolish it. There have been a lot of civil libertarians of both the right and the left over the years who have said secret law is intolerable in a republic because of the public need to know, right? If we're going to take a middle course, which is what I call reform it, we need some principles for living with secret law to bring some constitutional values in a more clear and systematic way. That's kind of what I advocate if I'm advocating anything as a scholar. And my first principle is what I call the public law supremacy rule, which basically adds up to if you're creating secret law, either positive law through a congressional annex, or you are a lawyer interpreting the law, you're writing a memo, this is going to have precedential value, whatever, or you're just interpreting the law, right? In your secret legal work, you need to be deferential at the highest level to the public law, right? The law that is public, the Constitution, the statutes, the court opinions, the public regs, right? They need to have greater kind of legal gravitational force than any classified legal authority you're looking at, because that's that public law, right? The Constitution, the statutes, the court opinions, right? Those are the ones that the public is aware of and that's fully invested with their sense of sovereignty and whatever, right? So it's basically kind of like a deference doctrine, if you will, hard deference towards publicly known law. And also I say the understanding of publicly known law that just like your average, smart person would have reading it. And so that's leaning against. So basically all that adds up to is basically when you're doing secret legal work, don't be aggressive. Don't deploy some aggressive, novel, creative theory, because I think number one, that's problematic in a system of popular sovereignty. And second, you're setting yourself up for a massive scandal. And because, you just look back at what's happened, several of the biggest scandals we've had since 9/11 have had secret law at their core. It's the torture memos, which deployed an aggressive re-understanding and narrowing of the torture statutes. Or you look at there was, some of you might remember, the Section 215 call data program that was released by leaked by Edward Snowden in 2013, where in secret DOJ lawyers and then the Foreign Intelligence Surveillance Court had looked at a provision in the USA Patriot Act, which the author of the provision in Congress said, like, we're talking about onesie, twosie documents, like a bill of sale for buying fertilizer, right? Like that's what they had in mind. But the lawyers looked at this and they said, well, let's get aggressive with this. And let's say that law allowing the government to get something that is relevant to an investigation, that could be everybody's phone records every day. That is a super aggressive reading of the law. They did that in secret. 2 branches of government were invested in it. And when that got out, people freaked out on the, civil libertarians of the right and the left. And a lot of the public just felt like, what are you talking about? I'd say my cardinal principle is don't get creative, don't get aggressive, do just kind of like leave it to beaver legal analysis. If you're doing it in secret, if you want to move the needle on where the law is, you need to, go way up the chain to the highest levels, right? And probably do it in publicly known law, because ultimately it's the public who are sovereign.
Well, Dakota, on that high note, I think we're out of time. So I really appreciate your insight, and you talked about an article that you wrote 9 years ago, but you're clearly still invested in and still interested in, and I think still has a lot of currency and value today. Really appreciate it. What we'll do is we'll post links to both the law review article and the just security and lawfare pieces to NSL Unscripted podcast for our listeners if they want to take a look. So thank you very much. Appreciate your time.
Yeah, absolutely. And I would add too, I keep, that was really kind of the framework article that I did on this in the Harvard National Security Journal. But I keep writing about the secret law phenomenon as there are new developments and, new evidence in the public record. So I'll send some of those links as well with, some of those recent pieces. But, really appreciate the chance to talk with you on your terrific pod. Really appreciate the attention of your listeners. If any of them are still with us, kudos to you. I'll see you in our next secret law scandal, which we're kind of, if you look at the calendar, like how often these happen, like 2005, 2013, 2015, we're kind of due for another one, right? So, maybe keep that article handy.
Yeah, will do.
This episode of NSL Unscripted was brought to you by the National Security Law Department at the U.S. Army's The Judge Advocate General's Legal Center and School. The views presented are those of the speakers and do not necessarily represent the views of the Department of Defense or its components, the Department of the Army, or the Judge Advocate General's Legal Center and School. Our department also produces the Operational Law Handbook, accessible online. We hope you have enjoyed this episode and look forward to future episodes for NSL practitioners. Thank you.